Okay, I think we're back. I'm sorry, I had issues with my internet, and I had to log in again. So anyway, for everybody who just joined, my name is Dobrina Ustun, and I'm an immigration attorney. My office is in Dallas, Texas, and we serve clients around the United States. In today's presentation, I will go over the H-1b CAP 2022 filings, since everybody is, super excited about this year's process. And throughout the presentation, I will go through the PowerPoint and share some strategies and some things to look for during that process. If you have questions, you can send it to me in the chat. I cannot promise that I will go over all the questions, but I will try my best. I also got some questions in my email and LinkedIn as well, so I will try to address as many questions as I can during the presentation. Today's agenda will be, I'll go over H-1b brief overview for those of you who are not familiar with the process and the H-1b in general. I will go over the registration process, H-1b filing, and a few tips for success. So what is an H-1b? H-1b visa is a non-immigrant temporary visa that is designed for those with specialty occupation to work in the United States. If granted, you will be able to work for an initial period of 3 years with the opportunity to get an extension for 3 more years for a total of 6 years maximum. Generally, we have 65,000 H-1b for foreign nationals with bachelor degree or equivalent, 20,000 H-1bs for foreign nationals with U.S. master's degrees, and you must have a minimum educational level of a bachelor degree in order to apply for the H-1b. You must have a valid job offer from a U.S. employer, and that job offer must be a specialty occupation that requires the use of your degree. So this is the very basic overview of the H-1b for those of you who who are not familiar with with the H-1b. The job must be a specialty position that requires the use of your degree. The position must require minimum a bachelor degree or its foreign equivalent to enter. The position is so complex or specialized that it only can accept professionals who have bachelor's degree or higher. An educational degree is a typical requirement for the position within the industry. The employer generally obligates candidates to have a educational degree or its foreign equivalent to operate in the position. So sometimes people, who have 3-year foreign degrees and a few years of experience or a master's degree from the United States, we have to do a credential evaluation in order to determine whether their experience plus education is equivalent to a 4-year U.S. bachelor degree. So if you have a 3-year degree, this is something that you have to bring up to your employer and the counsel who is helping with your case. The H-1b process. So since last year, the H-1b process. It's a 2-step process. The first one is the registration, where the employer and counsel will register the foreign national for the H-1b lottery. And if your registration is selected during the lottery, you will move to step 2, which is the actual filing of the H-1b. So what is the registration? This whole H-1b process is what I call it, employer-driven process. So the foreign national, the H-1b, potential H-1b worker is not involved in that process. Your involvement is basically to just submit your documents. as requested by the employer and or counsel. And with that, the employer is required to pay for the whole process and the fees associated with the process. So here is one of the most common questions that I usually get. Can I pay for the H-1b process, as a foreign national or as a prospective H-1b candidate? No, you cannot. It's required by USCIS and Department of Labor that the employer covers and pays for all the filing fees and the attorney fees for the H-1b. Potentially the only fee that you as a candidate can pay is if you choose or the employer wants to do premium processing, you can cover the premium processing fee, and that's the only fee that potentially you can pay for, which is currently $2,500. Everything else associated with the process, the employer needs to take care. And sometimes people would ask me, well, can the employer pay first and I reimburse them and so forth? No, you cannot. Employer is required to pay all the fees associated with the H-1b process, except the premium processing fee. So as the first step for the employer is they have to register, create an account on the USCIS website, and this is the link. So the employer has to create, if they don't have an account already, they have to create an account on myaccount.uscis.gov users/sign up. They can go ahead and do that right now. Now, once they have the account, registration opens March 9th. So between March 9th, 12 p.m. Eastern, and March 25th, 2021, 12 p.m. Eastern time, the employer and or counsel can register your H-1b for the lottery process. So you have a couple more weeks to figure that out and to notify the employer that they need to get an account and put in your registration. Once a registration is closed on March 25th at 12 p.m. Eastern, the employer will no longer be able to register more candidates. So it's very important to keep these dates and times on your mind and act accordingly with your employer and counsel who is helping with that process. So that's for the dates and the deadlines. So once during the registration, the employer will be asked to provide legal name. If they have a DBA, that's also required. To put it as information, the entity's EIN number, primary office address for the sponsoring entity, and name, job title, email address, and phone number for the company employee who will serve as authorized signatory for the sponsoring organization. So this is the information that USCIS will collect during the registration process for the, on the employer's side. What about the H-1b beneficiary? For each beneficiary, the employer must provide the following: full name, gender, date of birth, country of citizenship, passport number, if any, and whether the beneficiary is eligible for the U.S. advanced cap or will be eligible for the advanced cap at the time a petition is filed on the beneficiary's behalf. So this is the information USCIS will request during the registration process, and that will be for the H-1b beneficiary. Now, the other most common question that I get, and actually I believe somebody sent me an email asking about it, can two different employers put in a registration for the same H-1b beneficiary? Yes, they can. So if you have 2 or 3 employers that are interested in potentially sponsoring you for H-1b, they can register you for the lottery. Now, adversely, can the same employer multiple registration for the same candidate, no, they cannot. So if your employer submits 2 registrations, they will cancel each other, and basically you will be kicked out of the whole lottery process. So sometimes, things can get more complicated where the employer has different, they have different entities under one, under the employer with different EIN numbers. And in these cases, some of these things could potentially, they could potentially submit more than one registration, but this has to be reviewed by counsel, and just to make sure that it's not the same employer. So the takeaway from this is, yes, multiple different employers can submit registration for the same employee, for the same H-1b beneficiary. Same employer cannot submit more than one registration for the foreign national. Another thing to be careful with, and that happened a lot last year, since last year was the first time they implemented this process, is what happened was, the employer put in a registration, and then the council also put in a registration, because they didn't really, there was a miscommunication between who is actually going to press register. So you have to make sure, to the extent possible, because as I said, sometimes the H-1b beneficiary is totally out of this process. But it's something, it's good to remember that there can be only one person, either the employer or counsel, registering for the H-1b. Let's see. So as I said, it's gonna, USS will open CAP registration on March 9th at noon, and registration period will end March 25th at noon. Now, of course, if they don't have enough registrations, they might keep it open, but I wouldn't count on that. So that's why it's extremely important to register between March 9th and March 25th. Obviously, don't wait until March 25th at 11:59 and try to register. From what I remember last year, since this was the first time that they implemented this process last year, it was glitchy at the beginning, because a lot, basically, millions of people and registrations were flying into the system. So some people, we had to wait a little bit, like maybe a few days for the system to actually start working properly. I'm not sure if it's going to be the same this year, since it's already been implemented, but sometimes we can have glitches at the beginning of the process. So I think I already mentioned that. Then what happens after registration? So after registration period closes on March 25th, USCIS usually conducts 2 separate lotteries. They will start, at least that's what they said, the lottery will include all registration beneficiaries that will selected through the registration to meet the regular cap of 65,000. And then the second lottery will include registered advanced degree holders. Now, whether that's going to be the case or not, we don't really know exactly what they're going to be doing. But basically, between March 25th and March 31st, the USCIS will conduct that lottery, and will select the H-1b beneficiaries who will be able to file for their H-1bs. So they will notify us by end of March. That's what they said. And they will basically, how they're going to notify us, they will send, they'll update our accounts with a notification saying, and basically saying who was picked in the lottery, or who wasn't. So once they do that, they said they're gonna conclude that by end of March. People who were selected will be able to file their H-1b starting April 1st until June 30th. So we'll have 3 months to submit the actual H-1B petition. Obviously, if your registration was not picked in the lottery, that's where the process will end for you. So it's very it's very important to keep these dates in mind, so that when the employer and or consul requests documents or clarification on different things, you're ready to provide that information to them, since we are chasing time ultimately to submit that petition. So USCIS will begin to accept CAP petition winning beneficiary April 1st, and our filing period will end June 30th. Now, employers can file their petitions at any time during the filing period, but some cases might need to be filed early in the period. So it's very important for you to notify your employer and consul if the employer doesn't have then basically the employer is filing without an attorney, if your OPT and EAD is expiring before June 30th. For example, if an F1 student with an optional practical training employment authorization expires on May 15, must have their CAP petition filed before that date to ensure CAP gap authorization benefits through October 1st start date of their CAP petition. So generally we can file between, the window is between April 1st and June 30th. But if your EAD is expiring before June 30th, you have to notify your employer and on consul, so that they can act accordingly and file as soon as possible. I haven't heard if USCIS, I don't think they've announced whether we can use premium processing or not. Often they will suspend premium processing initially for the initial filing, and then they will open up after June or July for everybody who wants to upgrade to premium processing. If premium processing is available at the time of filing or even later, it's optional. It's not required, but if you choose to do it, USCIS will make a decision on or send an RFE within 3 weeks. So for some cases, especially if your OPT or STEM OPT is expiring before October, it might make sense to do premium processing, so that you know whether you're going to have an H-1B or not on October 1st. On the flip side, if your STEM or is expiring like in 2022 or 2023, or you don't, there's no point of premium processing unless you're really dying to know whether you're going to have that H-1B, or for whatever reason the employer needs to know. So everybody is different in that regard. Generally speaking, the USCIS must approve, or we need to have a decision by October 1st, since October 1st is the first day of your H-1B. So on October 1st, you will change your status from F1 to H-1B. Now, having said that, it's not uncommon for USCIS to have all these pending H-1Bs past October 1st. That happened last year, happened the years before, it always happens. What you can do at that point is either, if premium processing is available, you can file for, you can request premium processing in order, to push USCIS to make a decision. So, whether you can, whether you can stay here and work. Let's see here. So what should you do now, or the employer should do now, if they don't have an attorney and obviously wish to work with one? They should be getting one right now. You begin gathering all relevant information about the job and the prospective employee's qualifications. So sometimes we have issues, as I mentioned earlier, with degrees, degree equivalencies, multiple degrees, experience, that needs to be addressed, and basically to make sure that that candidate, the H-1b beneficiary, actually qualifies for the H-1b. Sometimes things pop up, like if the job title or the profession that you're in requires a license, but you don't have a license, obviously, that you're not going to qualify for H-1b. Like for example, attorneys. If I don't have a license, I cannot apply for H-1b as an attorney. There might be some other options for me, but not as an attorney. The same thing applies to licensed architects. So if the employer requires a licensed architect with a license and you don't have one, or you're in the middle of getting one, you won't qualify for H-1b. You might qualify for something else under a different job title, different SOC code, but it's not going to be an architect. So those are some of the things that employers and employees need to think about. Also, if you had prior experience on OPT, and you need to maybe reach out to supervisor, or let's say that OPT was you volunteered for brief periods of time during the OPT. It happened a lot last year with COVID, where people lost their jobs, and then they they either started volunteering for professors or for universities and other projects, just to keep to keep that OPT going and not go out of status. So now might be the time to reach out to these people and tell them potentially that you might need a letter from them, or a confirmation that you did like a month or two volunteer work during your OPT. And the reason you might need that for the last few years, when we get an RFE for H-1b, especially for H-1b, especially for cap H-1b, or new H-1bs. So we'll get the RFE, and whatever the issues might be, specialty occupation, the client's employer-employee relationship, and so forth. Always the last request would be to show the employee, basically that the employee complied with their F1 non-immigrant status. It has basically it's a default question now. It's a default request. And not only for H-1Bs, for other non-immigrant visas as well. They basically print them, even if you don't have any issues, even if they don't see that you have any issues, it will be there. So you will have to be able to provide, documentation and evidence, credible evidence that you didn't violate your non-immigrant status. Obviously, from last year's experience and what happened, with COVID and people losing jobs, and trying to get employed on OPT wasn't an easy task. So people, students would work for professors on different research projects and so forth. They would volunteer. Well, even though you can volunteer on your OPT, not on STEM OPT, you still need to keep working hours. You still need to keep some sort of, kind of like a plan or a calendar as to what you did, how long it took, and so forth. So I'm sure that we will be seeing a lot of these requests for status updates. I mean, to show that you maintain your status. So it might be a good idea to, if you have that issue, to reach out to these people who you worked for or volunteered for, and just sort of, put them on notice. I think that would be something that we will be seeing a lot this year with, if USCIS sends RFEs to show compliance with non-immigrant status. So here's some, I still receive a lot of questions about the new rules and what's going on, and I'm not gonna go into too much of detail on this one. since, you know, we have a new administration and things are changing pretty much, you know, every week, if not every day. But basically the other most common question is the lottery, is it going to be wage based? There was a rule that was proposed early or end of last year, early this year, that instead of having a random lottery, USCIS should have a wage-based lottery, meaning they will give preference to the, you know, higher salaries, and that's how they're gonna choose the H-1b beneficiaries. In other words, if they will, you know, the proposal was we'll start with, you know, all level 4s salaries and then, you know, go down. Obviously that's not going to be implemented this year, so that's all what you need to know. We don't have a wage-based lottery this year. That doesn't mean it's not going to come back next year. There's some indication that the new administration actually likes the wage-based H-1b sort of lottery, but to what extent, how they're going to implement, obviously we don't know that. But for this year, it's a random lottery. It has nothing to do with the wage. Now, since I'm on the wage issue, what you might want to think about though is the different wage levels. So we have 4 wage levels: level 1, level 2, level 3, and level 4. Obviously, level 1 is the lowest salary point or lowest prevailing wage entry-level position. Level 2, some experience. Level 3, more experience combined with managerial, and level 4 obviously is for some of the most experienced candidates. What happened 2 years ago, I believe it was 2 years, maybe 3 years now, USCIS came up with a memo saying that level 1 wage is not appropriate for H-1b, since the nature of the H-1b is that, you know, we're looking for somebody with specialty occupation and all these skills and education and so forth. Therefore, level 1 wage, which is the entry-level wage, is not necessarily compatible to you know, to our to the H-1b. So what happened was everybody that was filed with level 1 level 1 wage got an RFE on it, and half of these petitions, more than, I think it was half or more than half, ultimately got denied. Because the USCIS said that the level 1 is not appropriate for, you know, for H-1b. So since that happened, I mean, I advise my clients to think about level 2 wage. Doesn't matter you just graduated, doesn't matter that you just, you know, you don't have experience, but this is one sticky point where, you know, if you can avoid it in an RFE and ultimately in a denial, good for you. Obviously, some employers cannot pay that, you know, level 2 salary. So we go with level 1, but at least they're on notice that here are the issues that might come up in an RFE. Obviously, not everybody, you know, not everybody got those RFEs. Not everybody that got an RFE got denied on that issue, but there were a lot of people that did. So it's just a way to prevent yourself from, you know, experience getting an RFE and responding and ultimately getting a denial on that H-1b, if that could have been avoided from the very beginning. Again, that will be, you know, up to your employer. Obviously, they're the ones that will decide whether level 1 salary or level 2 salary, especially, you know, when it's for entry-level positions. But this is just something to think about. Let's see. We have, yeah. So basically, the new developments that came out of the White House in January, they put a stop on a lot of proposed rules, at least until mid-March for review. So we'll just have to, I'm sure that more things will come up after March. Or end of March in terms of H-1b and in terms of other immigration rules and proposals that will further this administration's immigration agenda. Filing tips. As I said, I will provide a few filing tips at the end. Obviously, start early. We are already in February 25th, 2021. Registration, H-1b registration opens March 9th. So we don't have that much time anymore, but you still have time if you are, if you're still looking for an employer or trying to convince an employer to sponsor you, you still have some time. Because they have enough, the employer will have enough time to open up an account and ultimately put in that registration. So for the employer, our advice is to review the final list of candidates, as well as the position, salary, and the candidate background. From the employer's perspective, they don't want to do a registration for somebody who doesn't qualify for the H-1B and then miss somebody actually who did. So now it's the time to review qualifications for the position, job descriptions, and so forth, in order to make sure that that's it's a registration that if selected actually has a good chance of getting an H-1B. Analyze the eligibility and likelihood of approval of the H-1B petition for each candidate. The same thing that I just said. You don't want to waste your registration and money on candidates that might not be qualified today, and then ultimately and then miss on candidates that probably had the qualifications. You can collect key documentation required for the H-1B filing. If the petition is selected, they can start the collection right now to make sure that the job description is there, qualifications are there. If there needs to be any certificates that needs to go in, the candidate actually has them. And of course, the salary discussions and documentation to support the LCA. So all of these things are basically small tips and activities that should be your employer should be doing right now. Even if you don't get into the lottery this year, all of that information will be very helpful for next year's lottery, or if there's any change in terms of the H-1B, new petitions, and so forth. So in order to get prepared and to make sure that H-1B candidate qualifies, now it's the time for the employer to go through all these exercises and make sure that they know who they're sponsoring and that person actually qualifies, and there's a good likelihood that they will get it approved. So I think that was my last slide. So here is my information, and let's see if if we have any questions here that I can answer. Let me see here. So this is a very common question that we started getting, obviously, as a result of COVID. How we file the LCA in this pandemic, with the residency or with the client location? So actually, I was on a discussion like a couple of weeks ago on this. So the way I file it with the client location, and at least, and if it's a consulting company, obviously the employer's address and the client location, not residency. Because if you do just residency, USCIS might say, well, if you don't need to be in a client location, and you can be, technically you can be anywhere. I mean, you can be sitting in in Netherlands and do the job, or India or China. So that's why I know there's some attorneys that put residency, but I think the safest bet is to put corporate address, because for the reasons I explained. If you can do that work from home, does it matter where the home is? It doesn't. for the most part. So, and also I have seen RFEs when we put home residency, you know, I mean, even before COVID, legitimately, some people were working from home. Then we'll get all these like, you know, 20 pages RFEs asking about the location and whether the individual, since they're working from home, whether they have a business insurance and that insurance, and you know, to show pictures of how the office is set up, and it was just insane. So to avoid all that, I recommend that I don't put home address, even with the pandemic. I mean, I understand, and USCIS understand the pandemic issues and all that, but as I said, if we don't put a corporate address, then and we work from home, I mean, home could be, as I said, you could be sitting in China and doing the work. So why do you need an H-1B and stay in the United States? So I would think about that. Yes, yes, I can share the slides, and if the recording actually worked, I would also share the recording as well. Are the dates in March the only openings during this year? Yes, as of right now. So March 9th through March 25th. I think I repeated that probably 1,000 times by now, but it's important. Yes, those are the only dates available for the registration. Now, last year, obviously, you know, everything was different last year. What happened was during registration period, which was March 1st through, I think, the 20th, USCIS got enough registration, so they closed the registration period. But what happened after March 20th, a lot of employers didn't petition for the H-1b beneficiaries. Basically, even though they went through the lottery, the employer said, well, you know, because of COVID, we have to lay off people and all kinds of other reasons. Employers did not send enough H-1b petitions. So USCIS didn't have, ultimately by end of June 30th, they didn't have enough petitions. So what they did, and they didn't tell us secretly, they ran a second lottery. And that's how some people were able to get in through the second lottery, because USCIS didn't have enough submitted H-1b petitions by June 30th. I don't know if, I mean, obviously COVID is still here, so I don't know if we're gonna have the same experience this year as well. Probably not. Last year was the first time ever that they did this. So as of right now, yes, this is the only opening, March 9th through March 25th. Okay. Okay, for instance, there's this question. If a student has 1 year OPT and hasn't gotten a job before March 25th registration point, and they find a job later in their year, what will the process look like? So if you don't have a job or employer who is willing to put in a registration for you between March 9th and March 25th, basically you won't be part of this year's H-1b cap. You will have to wait until next year at the same time, unless something changes. But one thing I want to point out is the job that you need to get for that H-1b, that job will actually start October 1st. So you don't have to be even working for the employer now. What you have to do though is for that employer to register you, and your job will start October 1st. So, or you might be working for employer A right now on OPT, and employer A is like, nope, we're not interested in sponsoring for H-1b for this year, or whatever, you know, the reason might be. And then, but you have employer B who is interested in putting a petition for you. It's just you're gonna start with them October 1st if you get the H-1b. So you might not have an immediate job offer for tomorrow, start tomorrow, but you know, the employer might be willing to submit a registration, because remember, this job is for October 1st. This job is not for tomorrow. So there's some flexibility in that regard. But if you don't have an employer who is, willing to put in a registration, between those days, between March 9th and March 25th, then once registration closes, that's it. There you cannot, even if you find an employer March 26th, that's it. Like you cannot, you cannot be part of this year's lottery. So that's it's unfortunate. The thing is, you can wait if you can, if you can get a STEM OPT for the next year's lottery next March. Okay, I think I addressed that question. Yes, the lottery is not wage based; it's just a random lottery. At least that's what they say. So we'll see. Okay, so traveling. There's a lot of questions on traveling. Generally speaking, I advise people not to. That's the safest. Especially given now COVID and all kinds of other things going on. And the safest is not to travel. So here's a question on, if selected in the lottery, can I travel outside the United States between April 1st and June 30th? That will depend on whether your petition has been filed before your travel, whether they requested a change of status in the United States or consular processing. So there's a lot of things to consider, and you have to, if that's your intent to travel during this time, you have to address that with employer and or consul so that you can get, the best and correct answer, because the answer could change whether you request consular processing or you request change of status. Is any salary requirement for the H-1b application? Yeah, so salaries obviously are based on those SOC codes determined by the Department of Labor. The salary is usually based, it depends on your location, the metro, your occupation, and basically what is the employer's requirements. So that's why when I was talking about the different levels, level 1, level 2, level 3, and level 4. So all of these are location based, and county based actually, and based on your job title, profession, and employer requirements. So for example, I'm sitting here in Dallas, Texas, level 1 software engineer. I believe it was around 70,000 maybe, or around that number. Now, obviously, that same job title in San Francisco, California, is not going to be 70,000. It's going to be more than 70,000. So, yes, so the employer will have to figure out through consul, most likely, what is that SOC code that they're going to use, whether that's, requires a bachelor degree, and how much is that prevailing wage, and whether they're going to do level 1 or level 2 salary. Okay, so job as a sales development representative will qualify for the job requirement. So that's a very open question, in the sense that we determine, so in order to determine whether you qualify for H-1b, we have to look at the job duties. So job title by itself does not tell me much, because I can be analyst for Facebook, and I can be analyst for NASA. So these are two completely different fields, two completely different requirements, but the job title is the same. So saying that is, we have to look at the job requirements and the degree that is required to perform those job duties. Is there a specific percentage of specific jobs, meaning how many ITs cap in the 85,000? There isn't. So we don't have 20,000 or 15,000 for IT, and another 15,000 for MBA, finance, and so forth. We just don't have a specific percentage for these types of, for a specific sector. What happens is, obviously, because we get a lot of STEM H-1Bs, because that's what people study here. So most of them, I mean, obviously there is a lot of, a lot of people in finance and, other fields, but yes, IT is usually number one. Okay, my OPT application is still in process. I have already accepted the offer. Is it theoretically possible for the employer to file an H-1b before I get my EAD card? Yeah, so I mean, they can do the registration. That's the first step. Whether, if you get selected, then, then they have to do the actual filing. But for registration, yeah, there's no problem as long as they're willing to do it. Is the wage decided on your base annual pay or the complete packet that includes the RSU and other benefits? No, so the wage it's your base, base salary. The prevailing wage cannot be a combination of bonuses and other things that the employer, or other benefits that monetary benefits that the employer offers. The only time when a bonus can be part of the prevailing wage, and that doesn't happen often, is if the bonus is guaranteed. So I don't know many companies, actually I don't know any companies that do a guaranteed bonus, meaning it doesn't matter how well the company does, it doesn't matter how well you do in your job, you get that bonus. So, but outside that, bonuses cannot be part of your prevailing wage. So we have the prevailing wage, that's your base salary, let's say, 75,000, and that's your prevailing wage. Everything on top, great, but cannot be part of your prevailing wage for H-1b purposes or other benefits. Are the levels different for different states? Yes. So as I gave the example, here in Dallas, Texas, software developer, entry level or level 1 salary could be, I think it's around 70, maybe 75. That number is different in San Francisco, California. And vice versa. If you're in North Dakota, it's probably less than 75. So they just have to, check and make sure that, they have those wages before they file the LCA, because that's when we're gonna need the wage. Is experience necessary to be a higher wage level? Not exactly. So this is not, it's not like the green card process or the perm process, where we look at experience and so forth. It's not necessary. Experience is not necessary for a higher wage level. They don't really need to, justify, or, if the employer wants you to be, if they want to give you a salary of level 3, well, I mean, that's great, or level 2, that's great as well. But that will be up to the employer and what they want to do. How to respond to an RFE. Yeah, that's a whole different webinar. But basically what's going to happen is USS will, if they see that, something is missing from your petition, some information or something is not clear, or they just want to send an RFE because they have nothing else to do, they will send a request for evidence, and then they will list, the things that, they were not happy with, and request documentation or explanation of different things, like, how did you show us that you maintained your non-immigrant status, for example. That's one. Or if you're in a consulting company, they might request more information on the employer-employee relationship. Show us that, the petitioning employer is really, has control over you versus the end client. So depending on the request, obviously either the employer or the attorney will sit and draft a response and try to answer to those questions. So once you get the RFP, you will, or the employer will have 90 days, or actually 78 days to respond. Now, because of COVID, they have extended the 90 days or 78 days with another 60 days. at least for right now. So if I get an RFE today, I will technically have 5 months to respond. They might change that as we, depending on how things will go with COVID and when we'll be able to get back to the offices. But as of right now, we have 5 months. So that's how you respond to RFE. I don't know if that answered your question, but as I said, that's a whole different webinar. Will there be a recording of this? Yes, there will be, hopefully. I didn't mess it up when I was setting up the Zoom, but yes, there will be a recording. As an OPT worker, is it bad to show an intent to stay? I'm not understanding that question, but if you mean like going from OPT to H1b, H1b is a dual intent visa, unlike F1. And under H1b, you can have both intents. You can have the intent not to stay and the intent to stay. So if that was your question, you're fine in terms of intent. How do we know if the employer has successfully filed our H1b? You can ask them, depending on who is your employer. If it's a big company like Apple, Microsoft, and so forth, obviously now they have their internal systems and internal team that deals with with the H1b process, and also deals with outside counsel or their immigration vendor. Some employers send updates to employees and telling them, okay, we register you now, we wait for the lottery. Okay, you won the lottery, now we're gonna move forward with the application. If they file, ultimately, if you get the lottery and they file, some companies will share the receipt number once they get a receipt notice from USCIS. Some employers will not do that. It just depends on who your employer is. But generally speaking, at least the employers that I have, we are pretty, pretty engaged with the foreign national. Most of my clients' employers, they would allow the foreign national to email me directly and ask for updates. Some employers will not do that. So it's different for everybody. But generally speaking, at least at the minimum, you should know whether, two things, well, actually three, whether you were picked in the lottery, when your H1b was submitted and given a receipt number, so you can go on USCIS website and check the status, and if you got it approved or if there was an RFE. So at the minimum, they should be the things that at least the employer should share with you. Do you help to find employers who can? No. So no, I don't. So that's a totally different business model. I don't have a list, or I don't facilitate resumes and share with the employer. Sometimes because I have large network on LinkedIn, if people share jobs and I see somebody like a recruiter or somebody like an HR company shares a job and I see it on LinkedIn and it says like, oh, we accept H1b or we file for H1b, EAD or whatever, then I'll share it on LinkedIn. But I'm not connected with any of these people or employers. I just find it helpful, like, if somebody is interested and when I see that they're actually sponsoring H1b, maybe that will be helpful for somebody. But myself, like my firm, no, maybe I should, but that's a totally different business model. What is the deadline for employers to set up an account on my USCIS? So they don't, obviously, they have to do it by March 25th. Doing it March 25th, that's a very bad idea though. So they will, it's better to start now. It takes like, I don't know, maybe less than 5 minutes to do it, assuming there's no glitches on the system. But you don't want to wait until like, the day of to start setting up accounts, because guess what? There tons of people will be on that website and trying to do the same thing. So the earlier, the better. So this is kind of long. Can H1B, okay, so that was another question that I got last year. Well, after, through COVID, can H1B holders do volunteer work if they lost their jobs? So no. If you lose your job, you have 60 days grace period to find a new employer that you can transfer, that is willing to transfer your H1B. Volunteering in terms of, I guess you can volunteer at the animal shelter, but volunteering for a for-profit corporation or an employer, it's actually, it violates all sorts of labor laws. So it's not recommended, and it's not going to help you with your H1B, to maintain your H1B. Okay. Can you please tell the difference between consular processing and change of status? Yes. So change of status happens when you're in the United States. Let's say you're on a F1 right now, and or you're on your OPT or STEM OPT, and you're filing for or applying for H1B. In the application form, we have different options, and one is change of status, because the foreign national is in the United States right now in a different status, or consular processing. So depending on your situation, depending on whether you want to travel, and whether you want to go for an interview, we can choose either change of status, meaning that you will change your status from F1 to H1B in the United States. And if it gets approved, you will actually get a new I-94 attached to the approval notice at the bottom of the approval notice. So that means change of status. Basically, that means that you have changed status from F1 or whatever other visa you had, or status you had, to H1B, or to something else if you're doing something else. That you change your status in the United States, and as far as USCIS is concerned, you're in a valid status. Consular processing means that, if you, as I said, if you're planning to travel and, you know that you're going to be there for, for some time, or whatever, whatever the case might be, and it involves traveling, we will choose consular processing. That means that if the H1B is approved, I will get an approval notice, just one page. There's no I-94 attached to it, and it's basically a consular notification. So USCIS will notify the consulate that your H1B was approved, and you will go for that H1B stamp interview in the US consulate in your home country. And if everything goes well, they will stamp with the H1B stamp, and you will travel back to the United States. Now, as I said, people have different, different plans, different situations. So consular processing obviously was working better before COVID, since consulates were open. Now they're not open necessarily, or very, very limited services. So that's the difference between change of status and consular processing. Now, if you change status here, you will, as I said, you will get an I-94, you will have a valid status for 3 years if you're changing from, F1 to H1B. But if you decide to go outside the United States and travel, you still have to do the consular interview, so that you can get that visa stamp in your passport and come back to the United States. So if you change status here and you plan to travel afterwards, you will have to go for the consular interview. So it's kind of two steps. If you do consular processing, basically you will be outside the United States, and you will do that interview and visa stamping, and then come back to the United States. So that's the difference. Okay, I think it's already 1 o'clock. I will answer a couple more questions. I don't want to keep everybody here for more than 1 hour. But this question, it's important, and it's a good question. Do you have any news or information for contract employees who will be applying for H1 client, prime vendor, and employer contractor? So I don't have any, any news in particular, but the way, obviously, there was a court case that, and a settlement actually between the USCIS and the plaintiffs, saying, and the USCIS said that, as part of the negotiations and the settlement, now we don't have to submit, end client information and vendor letters and so forth. Now, having said that, though, I still submit them where possible. I just don't want to leave any room for them to ask, additional information. And to be honest, even though there is a settlement, that doesn't mean that, the news got to that particular officer. So to be on the safe side, obviously provide as much as you can. How many applications does USCIS receive every year? Last year, I believe they received registrations. They received close to 200,000, I believe. It was 195 or 97,000, something like that. The previous year, we didn't have the registration period the previous year, so we will just have to mail everything April 1st. That was the process back then. I think they received 237,000 or something like that. So they always receive enough applications, at least for the last few years. So we'll see how this year it's gonna go. Without premium processing, how long does USCIS take to process the application, assuming someone gets picked in the lottery and employers file in early April? So without premium processing, hard to say, but I mean, usually a few months, usually, 3 to 4 months, 2 to 3 months. It just depends on what they're doing and what is the volume. But if you don't do premium processing, on average, people will start hearing from USCIS around, I want to say July. Of course, it's different every year. It could be August or September, and for some, for some H-1Bs, they were pending way past October of last year. So it just, it just depends on what USCIS is doing. But, average is around July, I want to say. And July, if you file in early April, obviously, if you file in June, not going to hear from them in July. But if you file in April, July, August, you might hear from them. How many weeks of pay stubs are required for filing for H-1B? I usually do, it depends, but usually we'll do about a few months, 3 to 4 months, sometimes 6 months. It just depends. I don't know. Where can we get cap amount, state-wise or city-wise? I'm not understanding that question. Can one candidate approach multiple employers for the lottery? Yes, as I said, you can have multiple employers filing on your behalf. Different employers, not your own employer. I answered that question. Let me see if there's anything good here. Do you think second lottery scenario is possible? Probably not, but we'll have to see. Hard to say. Do universities need to meet the March? No, so universities are cap exempt. So as a university, if you're working for an university, then they can file at any time. There's no H-1B cap for universities. Is there a limit on the number of lottery employer can file? You mean if that means like number of registration per employer? No, there isn't. Oh yeah, I forgot to mention the employer has to pay $10 per registration. Okay, I think I answered that. I'm on my master's degree working on CPT. Can I apply for H-1b? Yes. Okay. Is there a link to check SOC prevailing wage for every state? Yes, there is a link, but it's sometimes it's not. This is something that the best is if your employer or the attorney that they're working with is actually doing, because as I said, there's different codes, so we can have one we can have one job title, but that job title could fit into 2 or 3 different codes depending on the job duties. So sometimes it gets a little little complicated to really get that prevailing wage. So I would ask I would ask either the employer or the attorney on to determine and to help you with the prevailing wage. And some of those SOC codes, they don't even qualify for H-1b. Like one of them is a web developer. For example, web developer does not qualify for H-1b. I mean, there could be an argument for it, but generally speaking, does not qualify. So, and there are others that USCIS does not like. And we get RFEs and denials on those. Although there's nothing really wrong with the code itself or the job title, it's just that USCIS believes that for that job and code, SOC code, we don't, the candidate doesn't need bachelor degree. So it's more than just a link and a number. Okay. Okay, so I think I actually went way over time. It's already 1:10 Central, and I am gonna close the webinar. If I didn't answer your question, you can message me separately. And if you have any other questions, you can reach out. Now with the H-1b, with the registration and with the lottery, I want to wish everybody good luck, and hopefully everything you get selected in the lottery. And next time we talk or we have a webinar, we actually will be discussing applying for a green card, because now you're on a H-1b and you would like to pursue permanent residency. Thank you for joining me today. I hope this was somewhat helpful. And as I said, if you have any other questions, feel free to email me. Thank you, and have a nice day. Bye-bye.